These are the 12 justices who make up the Supreme Court.
All right.
They have the last say in the most controversial and difficult issues in the land.
Very often the law is on a knife edge when it comes to us.
Their decisions affect everyone, from MPs accused of fraud
Each of these appeals is dismissed
to millions of bank customers.
I'm afraid the big institutions of the law have just backed up the big institutions of finance.
Their decisions protect our democracy and shape our society.
Assume that or not assume that, or what does the Secretary do?
We're getting so confused.
For the first time, Britain's top judges talk about their lives, their work, and how they make their decisions.
I sometimes start writing a judgment and I don't know where I'm going to get to at the end of it.
What they decide binds every citizen in this country. But are their rulings always fair?
Well, fairness is sort of like beauty. It's in the eye of the beholder, isn't it? I mean, one side is lost.
Does the mix of the court reflect modern life?
There does become a stage when it is embarrassing that there is not a woman.
Do their emotions get in the way of their rulings?
One has enormous sympathy for the individual. You can see how much this case means to them.
And if they weren't there, what could happen?
The extent of the invasion of liberty would widen. People would simply disappear. Things would be silenced. The freedom of the press would be trampled on. It's our job to see that that simply does not happen.
Are their decisions always right?
Anyone who expresses themselves as absolutely certain is either a genius or a fool.
This court dispenses justice at the highest level. Everyone in the land is answerable to them. But who are they? And what makes them tick? In this film, 4 of them reveal how justice works. Their battles with the government, their struggle with emotion, and the responsibility of having to be right. It's 6 a.m. and Lord Phillips has been up for hours. As head of the court, what does he think you need to become one of the top judges in the country?
You need a good intellect, because ultimately what matters is a feel for what is the right decision. And this is a mixture of analysis and common sense, looking at the implications. It sounds a bit obvious that to be a good judge, you need good judgment.
Lord Hope, Deputy President of the Court, points out the importance of temperament.
You don't want to be the kind of person who rushes to judgment and sticks to it come what may. You've got to be prepared to adjust your own views, however hard you were attached to them to begin with, by the realization that you probably weren't right after all.
Lord Kerr believes that however well they do the job, they'll face tough criticism.
Each case must be approached with complete independence of thought, and hopefully the outcome will bring justice. But one man's justice is another's injustice.
Bye-bye, darling. Have a good day.
Lady Hale is the only woman in the court.
It's very difficult to say exactly what a woman brings, but every judge brings their own particular experiences and background into the job. We lead different lives from men. We have no choice. And it's a good idea if those different perspectives find their way into the law.
Until 2009, the highest court in the land sat in the House of Lords. They were the Law Lords. It was Tony Blair who made the decision to move them across the square and into their own building. The change, which took 10 years to enact, was intended to make a crucially important public statement: that the judiciary should be seen to be free from the influence of Parliament.
It's moved here primarily as the last step in the separation of powers. and in particular a principle that judges should be wholly independent of those who make the laws and those who are bound by them and who execute them, the administration.
When the justices make their decisions, they do so not only independently of Parliament, but with the unique power to reverse the rulings of all lower courts.
We are the final court of appeal, and so sometimes a case has had to be decided a particular way by the trial court and by the First Court of Appeal because there is a binding precedent which tells them which way to decide it. But we, of course, can say that the decisions of earlier or lower courts are wrong.
By rejecting earlier rulings, they establish new precedents. In these instances, they make new case law. They also have the freedom to interpret another sort of law, parliamentary law. And here they may even find there is no past case to refer to.
The law is made across the square by Parliament, and they churn out thousands of laws. And they're not all crystal clear. So issues arise. What did Parliament mean when they enacted this? The language is confusing. That's the kind of issue, if it's of great importance, that we will ultimately have to resolve. And in that kind of situation, you won't have much guidance from previous cases. You have to reach a novel decision on a novel point.
This unique role means cases of particular general importance or constitutional issues will end up in the Supreme Court. This is why the court should be seen to be separate from Parliament. One case demonstrated this powerfully, and the public were hooked.
Some MPs could end up in court as a result of investigations into their expenses.
3 MPs and a Lord were accused of submitting false expenses. They argued that they could not be prosecuted in a criminal court because submitting their expenses was a parliamentary procedure and that all procedures were covered by parliamentary privilege. This privilege had originally been intended to protect MPs' right to speak freely in the Commons.
It came to this court because it involved an important constitutional issue. In what circumstances can the courts investigate what's gone on in Parliament? So this was an important constitutional issue, and it so happened an issue of considerable public interest as well.
All rise.
The MPs were appealing against a lower court ruling which had rejected their arguments.
It is a point of really fundamental constitutional importance. Parliamentary privilege is a phrase which everybody knows about, and in a way it's a kind of umbrella which can be simply put up and people shout privilege and you think, gosh, well, that must be an end of it. In many cases it may be enough to scare people away.
As a mark of its transparency, all the proceedings of the court are filmed, so every moment of this hearing would be recorded.
These are the first criminal prosecutions of members of the House of Commons, based on a member's dealings with Parliament for over 300 years.
Thank you very much, Mr. Fleming.
The system is that the country's top barristers present the case to the justices. In this instance, they had to decide how far parliamentary privilege extended.
Suppose the Member of Parliament is so aggrieved by what a colleague has said in a parliamentary debate that he confronts his colleague in the bar and he stabs him. My friend Mr. Fitzgerald accepted, in answer to my Lord Kerr, that this is not covered by privilege.
The defence wanted to make it clear that the MPs weren't trying to avoid judgment, but that they believed it was Parliament that should do the judging.
This is not and never has been an attempt to take them above or outside the law. These are proceedings to ensure that the allegations against them are dealt with by the correct law, the law of Parliament.
The court had to decide whether the ancient claims of privilege laid out in the Bill of Rights were being abused, or whether they were actually applicable. After a 2-day hearing, the justices reached a unanimous verdict on the MP's appeal.
Each of these appeals is dismissed. The reasons will be given later. The court will now adjourn.
It was decided that scrutinizing the claims would not infringe freedom of speech or debate. The only thing it would inhibit is the making of dishonest claims.
Oh, by no means was it a foregone conclusion. It may have appeared to admit of an obvious answer, but that certainly was not the case.
Their ruling paved the way for David Chater to go to prison.
I think if we'd ruled in the other direction, the man in the street would say, well, I think there's something wrong here, because if one's dealing with criminal offences, you would expect it to be criminal courts who resolve it. They're the ones who are best equipped to do it. They've got all the rules to protect defendants apart from anything else. It's a little bit strange if they simply can't inquire into what looks like an allegation of an ordinary crime because it involved parliamentarians or took place in Parliament.
Since the court opened, it has ruled on a wide range of controversial cases.
2 convicted paedophiles have won the right to challenge their inclusion on the sex offenders register.
The Supreme Court today ruled in a case which goes to the very heart of Jewish identity and that age-old question, who is a Jew?
The importance of the court's independence has been highlighted by the increasing number of cases where the individual citizen is in conflict with the state. Much of the legal cut and thrust now revolves around the finer points of the Human Rights Act, as in this case, where the justices had to decide whether British soldiers are protected by the Act when serving abroad.
If Private Smith was not under the jurisdiction of the United Kingdom, then whose jurisdiction was he under?
Is that not really the nub of the problem?
The fallback position here is 81C.
No, it isn't. In prison, or in such a place, or in such circumstances as to require an inquest under any other act.
Yes, no, the Human Rights Act.
Ah, you think that's what that refers to. Oh, neat solution. Yes.
But the ruling went against the soldiers.
The Supreme Court has ruled that British troops are not protected by the Human Rights Act when they are on the battlefield abroad.
In another human rights case, gay asylum seekers won their right to stay in the UK.
To compel a homosexual person to pretend that his sexuality does not exist is to deny him his fundamental right to be who he is.
As these justices handle the most significant and sensitive cases in the country, how they are chosen is obviously crucial. They are appointed by an independent panel of other lawyers and professionals, not by politicians.
We're very fortunate that we are not political appointments. I don't really know what politics, if any, my colleagues have.
Could you be seen to be political?
Well, politics is not our business, and people might use the adjective of political against us, but that's not what we're about at all. We're the antithesis of politics, really. We're detached from the political process. We've been removed from the House of Lords in order to make it absolutely clear we're detached from that process.
Court rise.
However neutral they believe they are, judges have often been criticized for being remote from real life and therefore ill-equipped for the job. So what is the background of these judges? And what was it that tipped them into a life in the law? Edinburgh is the hometown of Lord Hope and his ancestors. He's descended from a long line of Scottish lawyers, dating back to the Lord Advocate to King Charles I. His choice of career seems in keeping with family tradition.
You wanted to see some pictures of my previous existence. This is me as Dean of the Faculty of Advocates. So I'm rather proud of that picture, which shows me holding the Dean's baton. And after that, I was appointed to the bench as Lord Justice General
of Scotland, and this is me looking very grim, as I thought was probably suitable for me as a judge in charge of criminal process in Scotland.
A life in the law may have seemed like a foregone conclusion, but it was not an easy choice to make.
I was a family of one of 6, so that such resources as there were had to be spread fairly thinly among us. So I've always had to work on the basis that I had to look after myself and my keep, which was why that decision initially was a very difficult one, because I didn't have any money to support myself through the early stages of the bar. But my wife, fortunately, we married shortly after I was called. She was a teacher, and we had enough to keep going.
Lord Hope remembers his initial sense of fairness and unfairness came from his childhood experiences at rugby school.
Certainly at school, yes, certainly when you were ticked off by a teacher for something you didn't really think you'd done. Yes, I do remember this. Yes, and you didn't often get a chance to defend yourself, actually. That was my experience. The teacher would say, you did something or failed to do something, and that was that. That was his judgment, and you didn't get a chance to say, hey, wait a moment, it was a mistake. I didn't mean to do that, or in fact, you failed to see what I did.
The court reflects the entire United Kingdom. Northern Ireland is represented by Lurgan-born Lord Kerr. His Catholic upbringing is not an area he will discuss publicly, though his career has inevitably been affected by the explosive mix of religion and politics. Lord Kerr was just 22 when he was called to the bar. More recently, he oversaw the Good Friday peace agreement.
No one in my family had been involved in the practice of law at all. If I'm absolutely honest, I chose law because I didn't want to do arts, and I probably couldn't have done science, and law seemed the only option.
Now living in London, his relaxed weekend routine starts by making breakfast for his wife.
I don't drink tea. I don't like eggs. I'm afraid I loathe Marmite. But I'm making them because my wife loves them. I say to her that I earn, in consequence, zillions of brownie points. But it's a bit like air miles, you never get to spend them.
Lord Kerr believes that it was the personality of the women in his childhood that gave him a driving sense of morality.
My father died when I was quite young, and I was therefore very much influenced by the women in my family. My mother, who's of an extremely strong personality, and my grandmother. I dare say that their influence imbued me with a sense of what is right and what is wrong. And of course, in the course of one's legal career, although one has to maintain a certain professional detachment, occasions arise where you feel strongly that a particular individual's interest requires to be vindicated. Darling.
Set your feet later. Keep moving a lot before you set.
Lord Phillips has presided over some of the toughest and most famous legal battles of the last 20 years. Including the trial of Robert Maxwell's sons. He too was privately educated and puts his life in the law down to one school visitor.
I first got attracted to the law when I was at school. A barrister came down to talk to us about the law, and I thought that sounded very interesting. So that when I went to university, I did a degree which included law, and I found that I enormously enjoyed the academic study of law as well, and that was the final matter that decided me that I would go into the law and go into the advocacy side of the law, become a barrister.
Attracted by the intellectual challenge of the law, as a young man, Lord Phillips had no idea which part of the law to go into.
When I started off, I went into a rather esoteric area of the law called Admiralty law, and that was really by chance. I had to do national service. I'd done my national service in the Navy. I'd learnt a lot about ships. So, pure chance, I started off in this area of the law.
Unlike his colleagues, Lord Phillips doesn't believe morality had anything to do with his career choice.
There are lots of things as a child I thought weren't fair. Usually they were very respectable decisions that my parents were taking. But I didn't go into the law because I wanted to put right things that were wrong. I went into the law because I thought it looked a very satisfying and interesting way of earning my livelihood.
Lady Hale was raised in Richmond in Yorkshire. She didn't start her legal career as a barrister, but as an academic lawyer specialising in social and family law.
My husband does most of the main course cooking, so I tend to do the starters and the puddings, and he does the main course.
She's the only justice who wasn't privately educated.
My life has been different from that of most of my colleagues. I went to a non-fee-paying state school, quite a humble school. It gave me a very good education, but I'm sure it was quite different from the education that the boys were being given. I went to Cambridge, and in Cambridge there were 3 women's colleges and 21 men's colleges. Now that was very nice for us. Great sex ratio. We had a good time, most of us, as well as learning a lot. But of course it was fundamentally unfair. And so you went through a lot of your early life realising that the world was not yet an equal place for women.
Given that Lady Hale's background is so different from her colleagues, why does she think she was selected?
Well, I don't suppose it did me any harm to be a woman, because there does become a stage when it is embarrassing that there is not a woman. When you first arrive in this body of very intelligent, powerful men, it takes time to work one's way in and learn and accept that maybe one could do the job as well as they're doing it. My husband sometimes says, well, don't you realise they were as frightened of you as you were of them? But I didn't see any evidence of that.
Lady Hale's appointment made history. But what difference does her presence make to the otherwise all-male court?
I don't know, of course, how my colleagues are when I'm not around. They may be just the same. I suspect that they mostly are. But one of the things about having a woman present is that it does become harder to express sexist views, that people begin to think more carefully about how they express themselves. But I wouldn't like to accuse any of my colleagues of being sexist, because I don't know.
All things being equal, I think I'd like to have 6 men and 6 women. But the fact is that the law is a tough profession. It's not all that easy to combine it with having a family. And so, unfortunately, quite a lot of women drop out. We draw our membership so far exclusively from the upper ranks of the judiciary. And there aren't all that many women in those upper ranks to draw from.
But the gender imbalance and the lack of any ethnic minorities are not the only criticisms that face the justices. The decisions they make impact on the lives of all of us, so how in touch they are with ordinary life matters. Yet they tend to live within a fairly narrow social circle.
Well, unfortunately, I can be criticised for the fact that I come from a particular background, but that was the only way in which people could get into the law, really, at the time when I started. I'm afraid I'm a relict of the old system, and people can make of me what they will, but I mean, that's just how it was.
How do you think people see you?
I have no idea. Really, it's very difficult to look at oneself from outside. I try not to be conspicuous. As I walk around London, I hope nobody dreams for a moment what job I do. I certainly don't proclaim myself as having any particular significance, and I'm often taken completely by surprise when people recognize me.
As head of the court, Lord Phillips is adamant that they are not out of touch.
We are ordinary people. We live ordinary lives. We take public transport. We, by chance, if you like, have ended up in this particular position, having started life in all sorts of different walks of life. I did national service in the Navy. I spent a year on the lower deck. I saw quite a wide variety of life in those days. We are ordinary people, but I think it's quite important that other people appreciate that.
Whatever their personal qualities, when it comes to making a decision, there is a set process which each justice must follow. Every stage requires a great deal of stamina.
It depends how much pressure I'm under, but I very often start my day about 5. Actually, this morning I'm working on a particularly difficult case, and it's hard to get it out of your mind, and sometimes I wake up even earlier. Today I woke up about 3 and got up and worked for a bit, went back to bed, and then got up again at 5. These are intellectual problems, not stressing problems, but nonetheless, if you're concentrating very hard on a particular conundrum, it doesn't go away, and so you have a few hours sleep which you need, and then the problem takes over again.
The first part of the process is a long and lonely task, a mass of reading.
The parties have to provide us with written arguments on each side, and those are quite detailed. They may be 100 pages long. We had a case the other day in which they produced for us over 400, we call them authorities, decided cases. Sometimes when you've read it up, you think, well, this is a very difficult issue. When I read the appellant's case, I thought that was utterly convincing until I got to reading the arguments advanced on the other side, which brought me right back. So I really haven't, at the moment, got a view on what's the right answer.
The next stage requires the justices to be at the court. Equipped with the facts from their initial reading, they will listen to barristers present both sides of the case.
All right.
What will be argued over are key points and principles of the law.
What's your position about that?
I can't. That is a counterfactual question, my lord.
The debates that are conducted in the court are, for the most part, extremely stimulating and of a very high order.
And well, we respectfully say that it is...
I mean, what's wrong with that analysis?
We respectfully say it's inapt to describe that as objective, and it's inapt because it would lead to the consequence that we've already described.
The nimble-footedness of counsel, the improvisational ability, the capacity to switch tack are all very impressive, and it's a very enjoyable experience to participate in.
That's a point in your favour.
It is in a different context. I know, I understand that entirely. I'm not riding it. Maybe I don't seem to be great.
The court breaks at lunchtime, giving the justices a chance to talk. It will be the first of many private exchanges.
At the end of the hearing, we have a meeting at which everybody gives a provisional answer, what they think the answer to the question that we've been posed should be. Sometimes everybody thinks the same and it's pretty clear and the odds are that nothing's going to change. Sometimes you could even have 3 different points of view as to what the right answer was.
Oh yes, views can be expressed quite forthrightly and firmly. And that's as it should be. I mean, there should be no holding back of strongly held opinions.
We try very hard to respect each individual's independence and each individual's views, but that's not to say that we don't advance our own views with a degree of advocacy, because after all, we all started life as advocates.
These hearings may take 2 or 3 days, but eventually the case will have been presented, and the judges decide amongst themselves which one of them will write the lead judgment. At that stage, it's back to gathering up an enormous amount of written material, cases to revise, and new material that's been cited. If Lord Hope is writing the judgment, it also means a long journey. The best way he can approach the task is to go where he can guarantee silence.
The problem in London is that because we're busy hearing cases all the time, you don't get time to settle down and really read and think. Whereas here I find it very peaceful. What happens is that I have a case like this, which I'm going to be writing a judgment on later, and I've carried north with me the written cases, for which I've been able to shrink down to a manageable size, which I can put in my bag. I couldn't possibly carry all the authorities that we're cited.
Having created the space for quiet concentration, Lord Hope can now approach the judgment.
The kind of work we do is very much an intellectual exercise of identifying issues and working them out according to their quality and their weight. And that involves a lot of analysis. You need to express yourself very clearly in writing. You have to have a clear idea of the thread you're following. And you need to be aware of the audience you're addressing. You're writing not so much for yourself as for other people who are going to have to use the judgment.
The aim is a balanced and just result. But as it's impossible not to have opinions or feelings, the question of impartiality is a serious one. It's at the heart of the idea of justice.
I don't think one ought to be too emotional, frankly. I mean, the trouble with emotion is that one tends to take sides based on emotion rather than rational thinking, and that isn't a very sound basis for judgment. Somehow, as a judge, you have to detach yourself from the emotion of the occasion, and you are probably the one person who can do that. You learn to become quite detached, actually. I mean, it's long experience in court work.
In the case Lord Hope is looking at, an individual's risk of bankruptcy hangs in the balance.
As it happens, this particular case is right in the field of emotion, in the sense that people's lives are being very much affected, and one can feel a genuine feeling of sympathy for the people who are in that position.
The system trusts that a judge will know the right place for emotion. Yet Lord Phillips recognizes there is a tension between the decision he may like to reach and the one the law tells him he should reach.
You need objectivity. You can't afford to let your own feelings or emotions take charge. Because what you feel, what you might like the answer to be, is not necessarily relevant.
This process of weighing up how you think and how you feel means justices may not commit to a decision until surprisingly late on.
There are some cases where, until you're writing the judgment, you don't see where it's taking you. It may be driving you in a direction which you really didn't want to go. But this is what the law says. There's no avoiding this particular answer.
It's because emotions do have a place in the process that a judge has to be so self-aware.
It'd be quite wrong to say that one doesn't feel emotionally. We have individuals who come into our court to hear how we are going to resolve the cases in which they personally have been involved. And some of these cases involve a great deal of emotion. One has enormous sympathy for the individual. You can see how much this case means to them. And sometimes you know that the decision that you are handing down is going to cause them immense distress. And that is something that you feel yourself.
One case where the justices were torn between following the law and following their feelings was a high-profile case that affected millions of people. Bank charges.
Millions of bank customers hoping to get a refund on overdraft fees will be disappointed tonight. The Supreme Court has overruled previous judgments, and it means there'll be no major investigation of charges on customers who go into the red without permission.
Many customers had felt bank overdraft charges were wrong and had expected that the Office of Fair Trading would investigate. But their hopes were dashed by one of the first big judgments of the court.
We have held that overdraft charges form part of the price or remuneration for the package of services that the banks provide to their current account customers. This means that the OFT cannot consider whether, in imposing those charges, the banks are giving fair value for money.
Campaigners felt extremely let down.
What we need is fairness. We haven't got fairness. We've been told it can't be assessed. The banks have got away with pilfering our accounts for years, and I'm afraid the big institutions of the law have just backed up the big institutions of finance.
Banking charges is a good example of a case which was potentially very puzzling for the public. The public might well have understood that the real issue was whether bank charges were fair or not. But that wasn't what we had to decide. We had to decide whether the OFT themselves could look into that question, and we decided, looking at the statute that set them up, that no, they couldn't. It was off limits for them.
Finding the OFT remit was laid out clearly in law, the court had no room to manoeuvre. They were not able to rule on what they thought the law should be, only on what it actually was.
I think, personally, I would have been quite in favour of the Office of Fair Trading looking into bank charges. It's a good example of a case where, if I'd had complete freedom to decide whatever I wanted, I might well have said, yes, you go and have a look at them. But we had to look at the statute, and we decided that, no, it simply wasn't within their terms of reference.
It's because the justices are bound by the law that there will be times when even they cannot deliver fairness.
You never like reaching a judgment which you think is not fair. You will, if you possibly can, reach a construction which you think does justice. But occasionally you have to reach a decision which you regret.
There are certainly cases like that where you're just unable, because of the way the law works, the way you're applying law, after all, where the result seems very tough, and one grieves for the individual who is affected by this, but you're trapped by the way the law works into a situation where you've no alternative but to make that decision.
In those cases, would you say that justice is being done?
Well, that's again a relative term. I mean, there are some things that are created by law beyond our control which you may think is not very just.
Justice obviously is a very important part of the work that we do. We are here to administer justice, but we are here to administer justice according to law. And there will always be occasions when one feels that the result that one is impelled to is not necessarily the one that one would wish to reach.
But even if each judge rules according to the law, justice very often faces another challenge. Once the lead judgment has been written, it is emailed to the other justices on the panel, and at this point it's quite possible that the others are unable to agree. The best that can be done then is a majority ruling with the dissenters writing their own judgments. But is that satisfactory? Doesn't that mean a different justice on the panel would have meant a different result?
Morning. If you sit 5 out of the 12 justices and you reach the decision 3-2, it's fairly obvious that if you had a different 5, you might have reached decision 2-3 the other way. This is one reason why, when we have a really important case, we sit more than 5, 7 or even 9, so that we involve a larger proportion of the court in reaching the decision.
It could still be 5-4.
You absolutely, and it quite often happens that you sit 7 or 9 and you break that way, because often when you do it, it's because the issue involved is particularly difficult. Or it may be a case where you're considering whether we ought to depart from one of the decisions we've made in the past. And That's the kind of knife-edge situation in which opinions can differ.
So what does that say about justice?
I think it says about justice that no judge is omnipotent and infallible. It's the art of doing the very best you can to get the right answer.
I think that anyone who expresses themselves as absolutely certain, without any shadow of doubt, is either a genius or a fool. I think that one can't be absolutely certain in a significant number of cases that one reaches a view on.
Making the best of an uncomfortable situation, the justices point out that there can be a benefit in putting these dissenting views on the record.
I think it's more satisfactory if we all form the same view with certainty. But sometimes, when it is difficult, it's not a bad thing to have a majority and a minority view. One can get things wrong. There have been cases in the past where it's become recognised that it was the minority, maybe even only a single judge, who had seen the case properly and got the right answer.
One judge may interpret the law differently because of what they alone bring to the case. It may be their legal or their personal experience.
There is quite a lot of room for individual interpretation. From time to time, one's own particular approach to concepts of justice and fairness comes in, as does one's own particular background and experience, which may lead one to look at particular factual situations in a different way.
For better, for worse.
For better, for worse.
For richer, for poorer.
For richer, for poorer.
A powerful example of how Lady Hale's experience as a woman and her background in family law could inform her view of a case was one involving marriage and divorce. In Britain, prenuptial agreements which set out what would happen financially if a marriage ended have not been considered legally binding. But in 2010, decades of legal tradition were challenged in one major divorce case. German heiress Katrin Radmacher, with tens of millions of pounds to her name, had divorced Nicola Granatino. Unlike most divorce cases, it was therefore the wife who was the wealthier partner and who had asked her husband to sign a prenup.
You say they were madly in love, and she says, unless you sign this, my father's going to disinherit me. It's any man who's madly in love going to say, oh, well, never mind.
Those were the circumstances in which she signed.
The court was being asked to make legal history and give some weight to the prenup.
Both sides were agreed they can't be binding. The judge always has a discretion to say the operation of this agreement in these particular circumstances would be quite unfair. That was common ground, that ultimately it was for the judge to decide. What wasn't common ground was how much weight do you attach to it.
Lady Hale took the view that prenups tended to work against the interests of women who had struggled for years to be treated equally in law.
A prenuptial agreement is designed to take away that equality, to deprive the less powerful party to the marriage of what she, and it is usually she, would otherwise be entitled to.
Mainstream feminist thinking roundly condemns these agreements as being oppressive and discriminatory.
Despite Lady Hale's concerns, all the male justices thought couples should be trusted to make their own decisions.
Ultimately, the prenuptial case seemed to us to admit of only one conclusion, and that was that here was a highly intelligent couple who had entered this agreement willingly. Therefore, significant weight should be given to it.
But Lady Hale thought there was something flawed in this logic. It failed to recognize that marriage is an exceptional contract.
People getting married are not in autonomous situations. It's not like doing a commercial deal. People make choices. They compromise their own interests for the greater good of the family as a whole, whether it's the other spouse or whether it's the children or whether it's all of them. At least one hopes they do.
Ultimately, after 2 days, there was a verdict.
A German heiress worth tens of millions of pounds has won a landmark divorce case at the Supreme Court. The judges have ruled that Katrine Radmacher's prenuptial agreement with her investment banker husband was valid.
The court's decision was a landmark. From now on, prenups could be given significant weight in divorce cases.
Katrine and her ex-husband had promised each other that if anything went wrong between them, they wouldn't make financial claims against each other. It was meant to be a marriage for love, not for money.
But it was a majority ruling, with all the men thinking one way and Lady Hale the other.
Well, of course, I mean, it's obvious, if I may say so, that people will immediately make a connection between the fact that the 8 judges who comprised the majority were male and the single justice who dissented was female. But in my judgment, there is no correlation to be made.
For Lady Hale, it was a blow for women's rights.
It was striking that all the men thought one thing and I thought something else. And so I felt it necessary to say so, but I hope they'll forgive me.
But the most serious battle the court has faced was not among themselves. It has been between them and the government. The issue is terrorism. The government on one side would be championing security, the judiciary, liberty. The event that triggered this conflict was 9/11.
An astonishing series of acts of terrorism has been perpetrated in the United States. Countless numbers of people were killed and injured when at least 3 apparently...
The Blair government responded with an unusual measure. They passed an anti-terrorism act that would allow them to lock up foreign suspects without trial.
The change was this feeling we're all under threat. And in a state of a national emergency, there's always a reaction to play it safe. If you're worried about somebody, lock him up. Well, you only have to state that proposition to realise the dangers it carries. Who's going to take the decision? The executive.
By 2004, the government had imprisoned 17 suspects in Belmarsh prison. None of them had been charged. The chain of events that followed threatened to destabilize the entire relationship between the executive and the judiciary. For not only was the government violating an ancient British principle, they were contradicting their own Human Rights Act passed 3 years earlier.
Just think about what the great majority of the British public would think if a member of their family could be hauled off by the police and locked up indefinitely, not told why, not given the evidence, not given an opportunity to challenge.
It's the thin end of the wedge. It's fine if you start on the assumption that they're not going to lock up anyone unless the individual actually is a terrorist. You just can't quite prove it. But the risk is that they're going to lock up people who are innocent, who are not terrorists. And these people are going to be there indefinitely, on suspicion. And that is such a horrific prospect.
In 2004, the highest court in the land was still the House of Lords, with the Law Lords presiding. And it was here that the case between the imprisoned suspects and the government ended up. The prisoners' lawyers pointed out an error in the government's logic. If the act was designed to lock up potential terrorists, why lock up only foreigners?
It doesn't take a lot of imagination to realise that that's not rational. Because there are plenty of homegrown, non-foreign terrorists whom they were not going to lock up, or suspected terrorists in the same way. And the one thing that the law does not allow you to do is be irrational.
The government's case hinged on whether the threat the country faced was so serious that they could depart from the Human Rights Act. If it wasn't, it meant the government was violating its own treaty and threatening fundamental freedoms. An enormous amount was at stake. The verdict made headline news.
Good evening. Today's ruling on the government's policy of detaining foreign terror suspects without trial is of such constitutional significance that 9 rather than 5 law lords sat in judgment, and they have delivered an extraordinarily strong denunciation.
Fundamental rights are protected in our democracy. They belong to everyone, whoever they may be, and wherever they have come from.
The law lords rejected the government case. Lord Hope recognised how much was at stake.
It's not very difficult to understand that if the rule of law were not there, then the pressures would go on pressing, and the extent of the invasion of liberty would widen, people would simply disappear, things would be silenced, the freedom of the press would be trampled on. It's our job to see that that simply does not happen.
The government reacted strongly and accused the judiciary of being irresponsible. Jack Straw went public on the radio.
The law lords, I understand their anxieties, and all of us are very anxious about these powers, are simply wrong. And on this huge dilemma of how you balance liberty and order, the most important liberty is the right to life.
They were very upset, I think, by our decision. It's a good illustration, I think, of the fact that in an acute emergency, decisions can be taken which threaten the rule of law and which require objective, dispassionate review.
At that time, did you have any doubts?
No, I thought the decision was absolutely right.
But the battle was not over. The government believed that there were terrorists living amongst us and insisted on special powers to contain them. The result was control orders, a form of house arrest keeping suspects confined for up to 18 hours a day. Within months of the new orders, the terrorist threat became a fact.
Central London is rocked by a series of terrorist attacks. Police speak of many casualties. The terrorists hit without warning at the height of the morning rush hour on the crowded transport system.
The case for control orders suddenly seemed stronger.
What has been confirmed today is that terrorist cells continue to operate to devastating effect in the UK.
The mood had changed. There was an intense nervousness, a jumpiness. How would the judiciary act now if a challenge to the new control orders came before them? The measures were designed to get round the Human Rights Act by restricting a suspect's liberty, not by depriving them of it. But the problem was distinguishing between the two.
The only control orders that you can have are ones that don't involve a deprivation of liberty, but only a restriction on liberty. How long do they have to be under a house arrest for it to be deprivation? How long do they have to be allowed out of the house for it to be merely a restriction?
Making this distinction was not easy, but it was essential.
It is extremely difficult to prescribe whether it should be 12 hours or 12 days, but the law acts on evidence, and what we require to be persuaded of is that there is justification in the form of tangible evidence for any encroachment on the liberty of the subject.
Suspects living under control orders challenged the government over the length and won. 18 hours was ruled unlawful. So next, the government settled on 16 hours, but moved a suspect miles from his home. Now, completely isolated from his family and friends, the question was whether this was so harsh that it was almost as bad as prison. The result was that in 2010, the new government found itself in court.
16 hours, you know, if you're the Secretary of State, that you are in very dangerous territory. And therefore, there's nothing wrong or surprising about saying, and you'd better have done your homework on the effects.
Had the government's control order virtually destroyed the suspect's family life?
We're talking about an individual who's only been moved an hour and 3/4 away from London.
With respect, it's a pretty big only.
I have members of my family who live in London and other members of my family who live rather closer than that, and the difference in the occasions on which I see them is quite enormous.
Well, conversely, one might also point to the fact that for some people, an hour and 3/4 by train is daily commuting for families to do.
Imagine the children's reaction to every week, every Sunday being dragged off to that place. I mean, nobody would expect that to carry on indefinitely, would they, Mr. Tan? Imagine it. Another Sunday, oh gosh, we're off up there again.
The government lost the case again. Separated from the heat of politics, the justices had decided that this control order went too far.
It's a how long is a piece of string question to some extent, and the kind of area where you need an objective tribunal listening to argument on both sides and ultimately drawing the line. But nobody can suggest that there is a particular right place and a wrong place to draw that line.
But all these defeats for the government have raised a fundamental constitutional question. Should an unelected court be telling a democratically elected government what it can and can't do?
We apply the Human Rights Convention because that's what Parliament has told us we've got to do. And until Parliament tells us otherwise, that is our duty, and we are complying with the wishes of Parliament in doing that. And Parliament hasn't taken the step of saying, right, we're going to tear up human rights. And it won't.
Why won't it?
Because it appreciates that fundamental human rights are of fundamental importance.
In fact, the present government is still talking about reforming the Human Rights Act. It also intends to replace control orders. But as long as Parliament is passing complex laws and signing treaties, there is potential tension between the government and the judiciary.
Everybody learns lessons, and the way the system works in this country, and it's to the credit of everybody, including the executive, I think, is that they respect decisions which are taken against them. They may not like them, but there they are. One hopes that that process will have, as it were, cleared the way for a future where the executive is more aware of what can be done and what can't be done, and the way in which it should go about its affairs.
We must be a bulwark against executive decisions which we are convinced infringe impermissibly fundamental human rights. And that, I think, is a fundamental precept. Its importance can't be overestimated, that the executive cannot have access to unbridled power.
This series of high-profile battles between the government and the judiciary have made it absolutely clear to the justices how crucial their independence is.
We have to fulfill the function we have as the guardians of the rule of law, and if it comes into collision with the political view, well, so be it.
The final Court of Appeal had always been independent of the government, even when they were sitting in the House of Lords. But this new, clear, physical separation between Parliament and the Supreme Court adds weight to this vital truth. Those who make the law should be answerable to the law.
The rule of law is a principle that applies in all situations. And once you, even if you're a government, have signed up to binding legal principles, there has to be somebody who decides whether you're complying with what you've signed up to or not. And the independent judiciary are the best body to do that.